Mr. Chairman, we're live.
Thank you. We'll call this meeting to order. This is your Corporations Committee. And if you would please take the roll.
Mr. Chairman, I'd like to introduce Ella Clint. Ella is a freshman in criminal justice at Gillette College, and she will take the role this afternoon.
Thanks, Ella.
Representative Brown,
Excused.
Representative Locke,
Excused.
Representative Heft,
Here.
Representative Johnson,
Here.
Representative Lucas,
Present.
Representative Webb,
Here.
Representative Weber,
Here.
Representative Yin,
Excused.
Chairman Knapp.
Here.
Mr. Chairman, you have a quorum.
Thank you very much. So we'll get started today, and I often say this is the hardest working committee in the legislature, and that usually means we have 3 other jobs. So some of us will be kind of going in and out today. We've got some bill signings and some people presenting in other committees. And so we'll just manage our way through this. I think we left off on Senate File 59. We just started taking testimony. Are there any legislators here to testify on this? No. Are there any organizations? Welcome. Please introduce yourself.
Mr. Chairman, thank you. Perhaps a face you weren't expecting to see during this bill. My name is Malcolm Irvin. I'm the president of the County Clerks Association. Simple ask, we would ask that you would consider adding county clerk along with our partners, the assessor and treasurer. Truth be told, Mr. Chairman, this one wasn't on our radar. There's a subject you're familiar with that has taken up quite a bit of our time. Not trying to make excuses, but this wasn't a bill that we had on our radar. Why would it be beneficial to add county clerk in this, in Senate File 59? Multiple pieces: vehicle titling, voter registration, land acquisitions. There's a number of duties our office performs. So, Mr. Chairman, we would just ask that the county clerk be afforded similar tools to our partners in the courthouse, the assessor and the treasurer. And with that, Mr. Chairman, I would answer any questions.
All right. Questions from the committee?
And Mr. Chairman, I apologize. I should have added, we have actually had individuals who attempt to register to vote using virtual offices or these non-residential addresses, which we've denied. But in the instance that we need to do a further investigation, I think this would be a beneficial tool in our arsenal.
Okay, thank you very much.
Thank you.
Appreciate it. Okay, are there any members of the public here to testify on this bill? Do we have anyone online?
Mr. Chairman, we do have one individual, Tara Berg. I will admit her now.
Okay, thank you.
Ms. Berg, go ahead. It looks, there you go. You're unmuted now.
Okay, Mr. Chairman, thank you. Sorry, I'm not real computer literate, so I'm sorry you can't see me today, although I've been ill, so that might be okay. Thank you for allowing me to testify remotely today, and thank you for holding this committee meeting over. I'm not going to take up a lot of your time today, but I want to give you a little bit of past experience as to why we're here today. And I was part of the committee that worked this summer, and I really do appreciate the Secretary of State and the Corporations Committee for getting us this far. What I share with you, and I sent you all my presentation that I did last April in Lander, as well as just some snippets of things that you might see which cause me concern. Secretary of State's office has been good, forthcoming with what information they can give us. the problem that I'm seeing is if someone uses another person's address, that person has to file an affidavit with the Secretary of State's office stating that those people were not allowed to use their address. When we first started this a year and a half ago, we had an influx of approximately 800 corporate filings that transferred from Nevada. When I reached out to the registered agent from Nevada, and it's in that information that I sent to you, he have to speak to me, that there was no information as a registered agent that he needed to share with me. So in prefacing what we do in the assessor's office, why it would even matter to us is one of our jobs, though not popular, and been discussed a lot this year, is to value all of the business equipment for properties located within our jurisdiction. So we have a lot of local people that are already paying on their personal property. That would be any business equipment they use, farmers, ranchers, computers, anything in retail business, your cash registers, shelving, all of that kind of stuff. So in being fair and equal and seeing the number of businesses that we had registering in the state of Wyoming, I tried to reach out and send them what we call a personal property rendition. Simply stating if they didn't have business equipment here, all they needed to do was send that back, sign it and say no equipment in Wyoming. So when we sent out 800 to an address of a registered agent in Lander that was actually tied back to this Las Vegas address, he sent them all back to me and said, I don't have to talk to you. And so I called the Las Vegas address and I said, is there some way you can just verify that if any of these businesses have equipment? No, we don't have to talk to you. You can send me 800 addressed envelopes and I will forward them to the addresses to the businesses and they can send them back to you. And so that's kind of what got us here. We called the Secretary of State's office and they said, yes, we know there's a lot of them. They're sitting here on our desk, but they haven't done anything illegal. And I will tell you that nothing there was illegal. And so then as we start sending out other corporate filings, and just to put this in perspective for you, in the fourth quarter of 2024, there were 40,999 corporate filings in the state of Wyoming. 40,000. 270 of those were in Fremont County. So I'm reaching out to 270 people to see if they have business equipment here, because the people who do have a business here are paying on that equipment. Again, I'll wrap it back to equal and fair. So as we're going on this journey, and as you see from my presentation done in May, we start sending them to these companies. They send them back, no address, no. So we start sending them to the owner's address that's on the filing form. We start getting information back from the people who actually either have a business or have a residence at the location address that's used on the registered agent's form. Those people start coming to me again, local level. They know me. They said, why are you sending me this? And I said, because your address has been used on a corporate filing at the Secretary of State's office. So when we started seeing those, we did reach out to the Secretary of State's office. I think you see in the presentation that I did an example of a gal from Lander who actually wrote to them and said, please do something with this corporation because it doesn't belong to me and they're using my site address. So as we start to find more and more of these, when we reach out and we talk to the Secretary of State, they said if those folks file an affidavit with the Secretary of State's office, they will look at dissolving those corporations. That's wonderful, and they have been wonderful at that. The problem is, how do these people know that their address is even being used if I'm not sending out any corporate paperwork? The second part of this is a lot of assessors haven't done this step yet. And I believe that the hardest hit counties are Sheridan County with the North Gould address and Fremont County with the corporate that we've seen. A few other assessors have started down this path, but haven't quite gotten there yet. It takes staff and staff time. My personal property appraiser has delved into this, and she takes the corporate recordings for a quarter and sends those letters out. Do I necessarily want in the depths of what's been recorded? Not really. I understand the Secretary of State's hesitancy in this because we as assessors, clerks, treasurers, oftentimes have paperwork that is confidential. We understand the need for confidentiality in the jobs that we do. But I also believe it's important at a local level when we see these things and know somebody's address is being used, that we are able to access any information that's been used, and maybe we can help facilitate some of this without 95-year-old people having to send an affidavit to the Secretary of State's office to get a corporation dissolved that is fictitiously using their address. One of the addresses that we had used, as you saw in my presentation, if you had a chance to watch it, was Chairman Case's address, and it was a vacant lot next to his motel in Lander. There's not even been an address assigned by the city of Lander for that vacant lot. So those are just some of the things that I've stumbled across. Do I think this could morph into more things? Yes, have been a couple of instances in the state of Wyoming where there's been some property taken. Deeds have been recorded, one in Albany County and one in Sublette County. People actually took ownership of a property. I don't know that it involved corporations, but I see the need for somebody checking this stuff. And with 40,000 of them being filed in one quarter, I'm not sure that the Secretary of State's office has the time to audit all of those. So that's what brought me here today. The Assessors Association has talked about this, and while I'm testifying on my own, they did vote to support all three of the corporate bills that have gone through this year. So all I'm asking for is a chance to maybe ask some more questions about some things I see going on in our county, that the clerk's office, certainly with all of the voter fraud things that have been looked at this year and the concern over that maybe we just don't have voter fraud, that we have some other things. And I don't want to take away from the fact that Wyoming's a great state to file your corporation, but I want to make sure that our constituents are protected in the state of Wyoming and especially Fremont County. And with that, Mr. Chairman, I'll stand for any questions.
Thank you, Ms. Berg. Are any questions from the committee?
I have one.
Representative Weber.
Thank you, Mr. Chairman. Thank you, Assessor Tara Berg. My question is, it certainly seems like you found a whole bunch of things going on in your county, and these were items or discrepancies and things that you have you reported these things to the Secretary of State's office as well?
Mr. Chairman, Representative Weber, some of them we have. What we're trying to do right now, Representative Weber, is reach out to these people, and I can report them to the Secretary of State's office, but what they tell me is they need to have an affidavit from the person whose address is being used in order to dissolve that. I just sent one last week to them that was filed with a foreign ownership from actually Singapore. Was the mailing address was Singapore, using an address in a mobile home park right here next to the courthouse. I sent that one to him, and the response I got was, it doesn't look on face value that anything's wrong with this, but we would need to know if that's who's actually living at that address. So I have subsequently sent one of our letters to that address, the site address, not the mailing address, the site address of the property, to see if EchoCell is actually performing business there.
No follow-up.
Okay.
Thank you.
Any other questions? All right, thank you for your testimony.
Thank you.
Do we have any other people online?
Mr. Chairman, we do not.
Final call for anybody here to testify on this bill? All right, we will wrap up with the Secretary of State.
Well, thank you, Mr. Chairman. Chuck Gray, the Wyoming Secretary of State, Colin Crossman, who I left. Mr. Chairman, want to talk a little more about our concerns on this bill. I appreciate, we're attacking fraud, and it's very important we attack fraud, but it's also important that we have collaboration. And, all the things that the assessor there in Fremont County has said about fraud occurring, we have only received one direct complaint from them that actually resulted in a dissolution, and that we know of. And we've done 60 dissolutions with the procedure laid out in state law that we really decided to ramp up in this administration. And so my concern on this is it really reduces the opportunity for collaboration. In order for us to get these dissolutions, the assessors and the treasurers and the clerks they're gonna have to collaborate with our office. And all the information that Assessor Berg was talking about that she needs, she already has through the website where these are posted. Now, what we're talking about here with this bill is what is given to the registered agents. And Mr. Crossman, with your indulgence, do you want to talk a little more about what's online and how I think that addresses a lot of their concerns?
Mr. Crossman?
Thank you, Mr. Chairman. So what is available in the public record online through the website right now? Anyone can look up is the registered agent's address, the mailing address, and the principal office address. Those are usually the addresses, those are the addresses that are being used when an individual is fraudulently filing an entity that cause mailings to go to someone's house. For instance, a couple of things were brought up earlier, one of them being a specific piece of land that is owned by someone who clearly isn't using it for that purpose. But that is the element of the public record. What this statute, what this bill attempts to get at is the information that is held privately inside of a registered agent. So registered agents are required to hold a set of information that the Secretary of State's office doesn't have, such as direct contact information, the names of membership, things like that. That kind of information is not public, and therefore is not being used by the entity as their sort of principal office address. You're not established at that address, since that address isn't a public address. So I'm not entirely sure how this bill gets at that aspect. Why do you need the private information when it's the public information that provides complete evidence of the fraud or false filing, as well as the establishment of the entity? So I'm a little confused about that, but that is what this bill attempts to get at, is the private information that is held by the registered agents. So if a law enforcement agency is attempting to do a criminal investigation, we can get that through a audit request from the registered agent and provide that to the law enforcement agent. But for the purposes of taxation, for the purposes of, I'm just not sure how this bill solves the problem that is being identified, I guess.
And Mr. Chairman, thank you. And putting the county assessors, the county treasurers, and I guess someone texted me that the county clerks now want to be in the list, that on the same footing as a court-ordered subpoena or bona fide law enforcement agency that is using this info in a criminal investigation, I think that is a policy change, and one that we're concerned about, especially in the light of it not really effectuating the goals that we want, which are collaboration, getting the info that is really going to lead to these investigations, and those investigations coming to fruition. And the other thing too, I'm going to text Assessor Berg. I was not on that email on Friday, so I want, please, I've sent emails and then also a letter to the assessors and the treasurers on this. Every single one of these it needs to come directly to the top of our office, because we want to dissolve these entities if they're fraudulent, but we also have a process we've got to follow, so we don't have people just making claims that aren't real as well, and then the person at that address, their legitimate entity, is being dissolved, and that has real implications for people. So with your indulgence, Mr. Chairman, I think Mr. Crossman wants to say one more thing.
Thank you, Mr. Chairman. I do have the precise example of this. We had an individual who saw a corporation that was established at their address. They were very nervous about it, sent in an affidavit. Well, the affidavit's sitting on my desk. I'm about to process it, and I get an email that I follow up on. Oh, wait, it's my son. Please don't file that affidavit, because I didn't know he did it. It turns out everything was perfectly fine. But there's a reason why we have the affidavit process, is to protect properly established things that, if you have a house and you have multiple people living there, one person may not be fully aware of what another person in the house, another adult is doing. In a perfectly, maybe they just didn't mention, I'm starting a company to sell my baseball cards or something. So perfectly fine, everything's kosher in that case, but we don't want to have a process where someone, even another government agency, can provide us with, hey, just please dissolve this company. No, we have a statutory process that we have to follow, and that involves evidence, and the affidavit is that evidence that we have decided rises to the level that get us to do this and do it safely.
Questions? Minority Leader Yin.
Mr. Chairman, thank you. Mr. Secretary, so I'm confused. You're saying you want to collaborate with these folks when they're trying to investigate fraud, but I'm not sure how you basically don't have the authority to give them any confidential information without the bill. And so how do you intend to collaborate with these individuals when they're pursuing fraud investigations if you are hamstrung in the ability to actually talk to each other?
Mr. Speaker.
Thank
I'm
you,
sorry,
Mr. Chairman.
Mr. Secretary.
Little promotion.
This
Thank
came
you.
from the floor, sorry.
Thank you, Mr. Chairman. What we laid out in our letter with the assessors and treasurers last year was that they need to notify our office immediately when they see fraud. And I was very concerned at that meeting that we had in Lander that there was evidence in fraud that the Fremont County assessor had that we weren't aware of. So I wanted to tell them, give them a procedure on what the notification process would be. But I have yet to personally receive, I believe, a single email off of that letter from the assessors and treasurers. We presented to the treasurers at Saratoga, had a really good meeting with them at their conference. And so I am really waiting for this communication. I really want to have it. And that would be the procedure, is they say, we have suspicions about this address and these entities. And this address or these addresses. And then we would reach out to the folks at those addresses, and they could reach out as well and lay out what that procedure would be, because in the testimony in Lander was that Assessor Berg had reached out to many individuals that said, no, I don't have entities at this address. And then the next step is, let's fill out the affidavit, which we've yet to receive with maybe 1 to 3 exceptions, but they're saying that there are hundreds of these cases. And so we need to have this communication directly so that I can help them and they can help us in getting the information to the potential victims, that this is the procedure we need to make sure that these entities are dissolved because they are not operating correctly at the address they're purporting to operate at.
Follow up.
Mr. Chairman, so I'm still confused. If a county assessor or a county treasurer is trying to find tax fraud, I mean, that's what they're trying to figure out, right? Is someone have property somewhere, or are they lying about having property somewhere? And they need confidential information from you. They can't get it without this bill, so they can't pursue an investigation. I mean, they can, I guess, go to a property owner and have the property owner file an affidavit with you, but that puts a burden on a property owner rather than just you two having communication, which you can't have confidential communication without the bill. So I am very confused on why, what the real pushback is here. Is there a reason that you don't want these officials to have confidential information?
Mr. Secretary.
Mr. Chairman, and this was what Mr. Crossman was getting at. The bill is dealing with information that is really different from the address fraud that was referred to in Lander, and that Assessor Berg had already identified the victims of that address fraud. Now, what we then need to do is either them or us or both of us give the victims the information they need to fill out the affidavit, and then we can dissolve that entity or those entities. And that's really the path forward. But this bill is talking about information that the entities are giving to registered agents. We don't think that is going to be super helpful to getting us to where we want to go in getting these dissolved, which is really about addresses being used falsely. And that's kind of a separate issue. And the question, I guess, from a policy perspective is, should we place county assessors and county treasurers and I guess county clerks and whoever else testifies that they want to be on the list on par with a subpoena, a court order subpoena, and a bona fide law enforcement agency pursuing a criminal investigation, which is the current sort of sideboards in the bill. Now, I'm not saying this is going to lead to all sorts of issues, but I still think that, you know, when you look at the way Title 17 is drafted, that I'm not seeing this really addressing the concerns that they're raising. And that's what I'm trying to say. And then it comes along with all these other policy considerations. And when thinking about whether the juice is worth the squeeze on this, that's all I'm saying. And I think it further diverts from what we've already struggled with the assessors and treasurers, is getting communication to a sort of upper management in our agency about what the addresses are that they suspect where the fraud is occurring, and then allowing us to, with that information, reach out to the potential victims and then help them reach out to the potential victims, which, based on the testimony in Lander, Assessor Berg has already identified potential victims that I assume have not filed with our office, because we believe it's 1 to 3, and there were certainly more than that Assessor Berg seemed to indicate she had communicated with at that meeting in Lander in April or May of 2024.
Follow up. Any other questions? I have one. So, is part of the reluctance the draw for Wyoming, the advantage to file in Wyoming of that confidentiality with these companies, unless there's a subpoena or unless there's some action taken to request information?
Well, Mr. Chairman, I'm not sure that's quite my concern. I don't like changing the statute books without a real reason to do so. Either something that we've identified or something that is going to come in the future that we've identified that we're trying to address. And I'm just not sure I'm there on this one. I think that the folks putting this forward maybe aren't fully understanding what's in this and how they already have everything in their toolkit to help us get to where we can dissolve these entities, which is the fact that the person at that address says, these entities aren't at my address. And all we need is an affidavit to that effect. And being able to match up all that information is all something they can do with the publicly available information on our website. Now, whether the juice is worth the squeeze to make this change, and yes, in some people's minds, maybe it will have side effects. I don't know what it will do in terms of our perception, but I don't think it effectuates what the assessors, the treasurers, and I guess now the clerks, quite where they want, what they think this is going to do, in my opinion.
And I guess, too, I'm just trying to understand the two different aspects of it, because one would be dissolution, a push towards dissolution of a fraudulently filed address, I guess you would say. And the other is criminal investigation of fraud, whether it's whatever with the treasurer, whatever with the assessor or clerks. Is that correct? There's two different aspects to this. One is the dissolution and moving towards that, which would have the authority in your office and run through your office, or any other investigation of fraud?
Well, Mr. Chairman, those investigations of fraud would really bring in the AG, not the assessors, treasurers, and clerks. And one frustrating thing about being SOS is I get probably 5 emails a day on fraud, and every single one in terms of not business fraud, but fraud related to what the businesses do. And all those I have to send over to the AG
Okay.
because I don't enforce that. I enforce business fraud, but not fraud, someone didn't send a person their good that they paid for online. That's not something that we have any enforcement authority over. That's one example.
Okay. I'm just trying to understand the direction of this proposed legislation as well, so.
Yeah, we're a little bit confused on it as well, what it's trying to achieve.
Representative Lucas, you have a question?
Yes, thank you, Mr. Chairman. Mr. Secretary, so I'm just trying to follow the logic on this. So a county official suspects there's fraud, and then is the first thing that happens, they contact the registered agent to contact the business primary? Yeah, and then I'll have a follow-up on that.
Mr. Secretary?
Thank you, Mr. Chairman. So there's, I guess, a couple different ways this could play out. If an individual, county employee, state employee, private citizen, were to suspect that a business was using an address falsely or fraudulently, any of those could reach out to our office if they have, as long as they have sufficient information that they can sign an affidavit stating that they know it to be a false or fraudulent use. And they can certainly tell us that they think there's a problem, and we will look into it. But without, because we have to protect both sides here, we can't just use that as we're going to dissolve it because it's clearly, but that said, there's, if there's other types of fraud being done, like for instance, the Secretary had mentioned that the business itself is committing fraud, not is fraudulent itself, then that has to go to law enforcement. So once it's over to law enforcement, then the subpoena component of this and the law enforcement component would come into play, and they would have access to that information. But on the sort of civil or administrative enforcement side, that's where that's what we're talking about, this bill adding into it. And I don't know how that, well, first of all, for a fraudulent business, I don't know how that helps, because the fraudulent business component is the public record side. As to, say, a county assessor attempting to determine the tax aspects of it, it's really if the business is physically here in Wyoming. If they're not physically here in Wyoming, then there's no tax to assess. And that's also based on the address and communicating through the registration. I don't know how this bill solves that problem either. So on the fraud side, they just have to communicate with us, and it does require the affidavit. But on the criminal side, that's already addressed by the statute.
Follow up?
Yes, thank you, Mr. Chairman. So in the normal course of business, the assessor, for example, would need to contact the property owner to see if there is any property that needs to be declared for tax purposes. And so they can't do that, and then they realize there may be fraud. Wouldn't the next logical thing be to contact law enforcement or let somebody else who, I don't know how deep they get into criminal, I don't know how deep you guys do, but I know we have an attorney general for things like that too. So I guess I'm just a little fuzzy on, how this is helping in that process.
Mr. Crossland?
Thank you, Mr. Chairman. So yeah, that's also, I'm not entirely sure myself as to how this helps with that, because once if you're suspecting criminal level fraud, then that's clearly what you do. You don't go further here. And if you're suspecting that you need the entity shut down, that's entirely within the purview of all of the things that are already out there. So it's where I'm struggling with this bill is, what does this add to this process?
Follow up? Any other questions? All right, thank you. With that, I will close public testimony. Committee, what's your pleasure?
Mr. Chairman, move the bill.
Moved by Minority Leader Yin. Second by Representative Heft. All right. Any amendments to the bill? Minority Leader Yin.
Mr. Chairman, I have two amendments. I'll go with the one that I was thinking of first before we had the clerks come up to us. I want to tighten the language a little bit. So on page 2, line 7, where it says official business, before official business, put an investigation related to. And so it wouldn't be for any business whatsoever. I think keeping it limited to investigations, I think is useful. And so that would be my amendment.
All right, is there a second to that? So is your intent a criminal investigation, or is it just an investigation period from the county?
Mr. Chairman, thank you. So criminal investigation is a very specific wordage. So I didn't want to use the word criminal. So, right, if it's a fraud investigation, it wouldn't necessarily be a criminal investigation. But I think that tightens it more than just like, I'm going to ask the Secretary of State because this person forgot something on their form. I want to limit it to an investigation of some sort. So that's all. So to repeat the amendment, it is just to add an investigation related to, and so it would read, to a county assessor or county treasurer to obtain the information for an investigation related to official business.
All right. All right, it's been moved and seconded for that amendment. All those in favor signify by saying aye. All opposed? No. That amendment does not carry. Any other amendments? Minority Leader Yin.
Mr. Chairman, so I will add the county clerk, so I think the easiest way is just on line 6 after assessor, comma, county clerk, comma.
And do we want to add that on 10 as well?
Yes, Mr. Chairman, thank you for catching that. Yes, please.
All right. Do we have a second for that amendment? Representative Webb, second.
So Madam Chairman, Mr. Chairman, sorry. Mr. Chairman, I think that adding county clerks allows them to investigate election fraud further than they already can, and I think it's a good tool for them to have in the election fraud toolbox. Mr. Chairman, it may not be election fraud, so it could be something to do with titles or deeds, but I think the biggest realm for them to possibly use this is people who say that they live somewhere, they don't actually live there, right? So they have some business registered to a location, maybe. So I don't think I could hypothesize for all the things that they could use it for.
Yeah, it would probably be needed for anything that was unusual that they wanted to request information for. So Representative Webb.
I don't have any further comment, just that question that I asked when the mic wasn't on.
All right. Any other questions on or discussion on the amendment? Representative Lucas.
Thank you, Mr. Chairman. Yeah, I'm a little confused about, I'm skeptical that it would lead to any help in an election fraud or election integrity issue. I've been a registered agent, I am a registered agent, and I literally just have contact information for the principal. No deeds, no titles, none of that, because literally they're just there to provide service. So I am served with documents, I bring those, give those to the principal. I have never seen it. That doesn't mean I know everything, because I certainly don't. But I'm kind of skeptical on that little piece of it.
discussion. Yeah, I'm wondering when you use an address like that, though, even in title work or anything else that could be affected where the clerk could be involved, so. Right. All right, any other discussion? All those in favor of the amendment, please signify by saying aye. Aye. All those opposed, no.
No.
Motion does not carry. Any other amendments to the bill? All right, seeing none, please take roll on Senate File 59, Registered Agents Release of Records.
Thank you, Mr. Chairman. This is a roll call vote. Senate File 59, Registered Agents, Release of Records. Representative Locke?
No.
Representative Heft?
No.
Representative Johnson?
No.
Representative Lucas?
No.
Representative Webb?
No.
Representative Weber?
No.
Representative Yin?
Aye.
Mr. Chairman, I have an absentee vote for Representative Brown of no. Chairman Knapp?
No.
Chairman, 1 aye, 8 noes.
With that, Senate File 59 does not pass committee. Moving on to the next bill. And I'm going to turn this over to Vice Chairman Locke. I have a bill signing to go to, and I will be right back.
Thank you, Mr. Chairman. Senator Rothfuss, please proceed.
Thank you, Mr. Chairman. Thank you, committee, for being here. Senate File 95 is Special Purpose Depository Institution Amendments. This was work we did during the interim through the Blockchain Select Committee, but we're not allowed to sponsor legislation related to Title 13 without going through a committee. So you see that it's individually sponsored, but it was work from the Select Committee. So we did some extensive amending during the interim. Special Purpose Depository Institutions, for those that aren't familiar, is a special Wyoming unique chartered bank structure, a state chartered bank, where the bank is a 100% depository institution, 100% reserve. So in other words, it doesn't do any lending of any sort whatsoever. It's actually 102% is how we structured it. And then it's able to custody digital assets as well. So this is something that we work with for whether it's cryptocurrency or other digital assets, it's capable of holding that. We have 4 of these institutions currently operating in the state of Wyoming, and we have others that are in the application process. There's a long and storied past to this. If you want to learn more, I'm happy to tell you as much as you like, but I know that you've got some time limitations, so this is probably not the appropriate time to learn everything there is to know about Speedy Banks. We passed this for the first time, I believe, in 2019. No, maybe a couple years later, 2021, I think, for Speedy Banks. We've had a number of different bills amending it over the years because this is the first of its kind in the country. And so as a result, as we've grown and learned, we've come back and provided some amendments. And this is simply the most recent bill to provide amendments and updates based on stakeholder input and based on the interest that we've heard. And so I'll go through the amendments that we have in this legislation. It basically does 3 things. The first is to provide a pathway. This is the first portion of the bill, pages 2 through 5, is a pathway that we worked out during the interim to allow a special purpose depository institution, which is a banking institution, to transition or convert to a public trust company. Public trust companies can also custody digital assets. So it is a path for an alternative system if the banking system is no longer desired. Now, candidly, the reason for this is that in the past, there have been some challenges with the Federal Reserve causing struggles for our special purpose depository institutions. And if those struggles continue, it might not be the appropriate business model to have full banking supervision just to custody assets when you don't have access to the Federal Reserve. Some of our speedies would not make a conversion, but we have at least one speedy that might be interested in doing a conversion to a regulated trust because it's simpler from a regulatory standpoint. And if you don't need the banking aspect of it and don't have access to the Federal Reserve, it's unnecessary. So we spent a lot of time working with the Division of Banking on these provisions, pages 2 through 5, which just provide a clean runway for an expedited process if it's simple, But if the board, if the banking commission decides that it needs to engage because it's complicated, then they're able to engage with a formal hearing. So it's a good approach that is relatively conservative in its ability to use the banking commission if necessary. The second thing that this legislation does, which begins on page 6, is there's interest in providing more retail and consumer-facing capacities for these special purpose depository institutions. It's already allowable under law, but you kind of have to nuance your way to it. When we established the Speedy Bank in the very beginning, we wanted to start off with the utmost consumer protection, so we insulated it entirely from consumers, and it was basically just business to business. We knew that over the years, we'd get to the point where we felt comfortable with it, and so we want to give it access where consumers can directly engage instead of it just being business to business. So this is the year we decided to move forward on that. There's still no lending. Let me be absolutely clear on that. These institutions are 100% reserve. There is no lending, but it is a capacity for a regular customer to engage. And so there are a few changes that recognize that. The first of those is the Romanet 3 that you see on page 6, where in its original format, institutions, these speedies, are required to maintain deposits. Any depository is required to maintain not less than $5,000. We take that down to $1,000. And the reason we don't take it down to 0 is because of this concept that they cannot lend. So when you have your traditional banks and your traditional credit unions, you're used to having overdraft protection. Overdraft protection is lending. We call it overdraft protection, it's lending. They're loaning you some money, you pay them back, that's lending. You can't loan money with a Speedy Bank, so we can't go to 0 because every time it goes negative by accident, you have a violation for the banking institution because they have lent money. So we take it down to 1,000 instead of 5,000 to make sure that there's a good bit of wiggle room, and then we allow the last sentence: a depositor shall not be deemed in violation of this paragraph unless the total deposit amount is less than $1,000 for 5 or more consecutive business days. In other words, that gives a little bit of squishiness where the bank doesn't have to report a violation to the Division of Banking if it's corrected quickly. And that helps to then avoid automatic dings against these special purpose depository institutions for doing what is effectively standard business practice and give a little bit of wiggle room requested by the Division of Banking. As we go to page 7, the language that's new on page 7 it's new language, but it's consistent with how things are done, and it has to do with auditing practices and the way it's calculated. We're talking about the capital, the authorized capital stock, and undivided profits, how that's calculated. You can ask the banking commissioner exactly the details, and maybe he can tell you in fine detail why this is an important little bit of language from a auditing and accounting standpoint, but it was requested by the Division of Banking to provide more consistency with how we do it with our traditional banks. The repealers are important. There's 2 concepts here. The first portion of repealers in Title 13 are all related to that retail customer discussion that I talked about. So there's some repealers that allow then a retail customer to come in and engage directly instead of it having to be business to business. And then effectively the third thing this bill does is that repeal of 3429-104N. For the Speedy Banks, there was a special specific supervisory fee of 0.2 of a mil on the digital assets that were held. We have not needed that additional supervisory fee because the Banking Commission has, through rule authority, the capacity to provide supervisory fees as necessary to sufficiently supervise. We thought there might be an additional need. That turned out not to be the case. So we're removing the additional supervisory fees. So now the supervisory fees for a Speedy Bank are the same supervisory fees under the same regulatory structure as a traditional state chartered bank. And again, that's deemed sufficient by all the testimony we heard by the commission. That's it. It's just a split effective date and other things. And I also have given you an amendment. The amendment is a 4th thing that has come up that we worked on, and we didn't quite have it ready for the Senate to take it into consideration. So I would just ask that you give some consideration to this. I mentioned the idea of converting from a Speedy Bank to a regulated trust, public trust, as an option. This is another type of conversion path where if that special purpose depository institution wants to convert to a bank, they have a pathway. This is much more rigorous because your bank is going to have capacity for lending. A Speedy Bank does not have capacity for lending, so it's going to be a lot of work to get through this process, and you'll have to go to the full commission effectively. But this allows for a pathway where right now you would have to dissolve and reform, and that's obviously not something that's in the interest. So that would be an ask as an additional fourth amendment to the Speedy Bank legislation for your consideration. I'll pause there and see if there's any questions.
Thank you, Senator. Questions for the senator? Representative Yen.
Mr. Chairman, thank you. Minority Whip Rothfuss, I'm trying to remember over the summer, and it's so hard when we're this late in a session. The conversion to state bank, are there entities that are considering this currently?
For the
Senator,
amendment,
sorry.
Mr. Chairman, Representative, thank you. For this conversion, there is that possibility, and it's based on the idea that now, under the current administration, some banking regulations might open up. The FDIC is now going to be less resistant, so it might be appropriate to have a full state chartered bank. And that's the potential impetus that would allow for this. Whereas previously, under the prior two administrations, there was no possibility of receiving FDIC insurance. And therefore, we had to have an alternative system, which was what the impetus for the Speedy Bank. Now things may change. This would allow then the possibility for that usage, but again, not without a thorough Herculean process of oversight by our banking commission and division.
Thank you, Senator. Other questions for Senator Rothfuss? Yep. Representative Lucas, please.
Thank you, Mr. Chairman. Senator Rothfuss, thank you very much. This is very interesting to me. So is it then that FDIC insurance is currently not available to Speedy Banks?
Mr. Chairman,
Senator.
Representative Lucas, that is correct. And even that could change and they could potentially get FDIC insurance. We still require them to be insured, but not through the FDIC. That was actually the original impetus for the Speedy Bank, was the Operation Choke Point concept, where certain institutions, including anybody involved in digital assets, was debanked and was not allowed to have a bank account in any way. So we worked to create a financial institution that would allow it. And the question was then, all right, how do we create a bank that doesn't need FDIC insurance? And that's where the Speedy Bank came from.
Follow up?
Yes,
Thank you,
Representative
Mr.
Lucas,
Chairman.
please.
Thank you. So you do that, these banks though are required to have private insurance, deposit insurance of a type.
Senator.
Mr. Chairman, Representative Lucas, that is correct. They're required to have insurance, but they're also 102% reserve minimum. So the insurance isn't going to be that staggering, since they basically have to lose the money literally. So it's not quite what FDIC is doing, where you've got leveraged funds and you have the possibility of risk. But yes, there's a provision in the existing statute that requires insurance.
And just a comment, and a
Please.
pretty hefty capital requirement, it looks like. Yes, thank you.
Other questions for the senator? So, Senator, just a few from me more than anything. I'm very new to this, so please bear with me. So this is a banking entity that we put in place here in Wyoming that's truly, fully unique. And it's been operating since 2021 at this point?
Mr. Chairman, I believe 2021, we can ask Jeremiah Bishop when the first one went into existence. I think it was 2021. And yes, we are the only state that has this type of institution. It's the first new type of banking charter in over 50 years in the United States. And we draw an awful lot of attention based on this incredible system. But the Federal Reserve actions have held it back, and we're hoping for a favorable outcome now.
Thank you. Just following up, Senator, so this entity, we have 4 of them today. That's what I heard you say, that are actually live and working. And then just making sure I'm crystal clear, this really has three major changes. And I'll be honest with you, I think I caught the first two best, is this conversion to the public trust. So you could convert one of these to a public trust. The second was basically allowing the retail component of this. And then the third piece, if you could just clarify a little bit for me, I'm just trying to be sure I'm clear. Thank you.
That was the supervisory fee, the additional supervisory fee that we had in place for Speedy Banks of 0.2 of a mil on the depository. That has proven to probably be a bad idea based on the current financial circumstances. It hasn't really held anyone back substantially, but it is an onerous and different burden than we place on our traditional banking institutions. So there's no reason for it. We're removing it to level the playing field.
An additional question, and I apologize, I'm learning here. So in this particular case, you've allowed this retail component of this. Do you, and just, I know it's much deeper than this conversation, so I'll bear with me. But do you feel like the insurance, the protections are sufficient? Because we're going from this business to business, let's say, likely savvy environment to retail, this retail concept. Are these people protected appropriately? And I'm not a big protectionist, but just your discussion around that.
Yep, Mr. Chairman, we bent over backwards to make sure that this was probably the safest institution you could put your money into, and I still believe that's the case. We have, as I said, three independent levels of surety that traditional financial institutions don't have, even with the FDIC insurance in place, right? That's capped. So I think this is about the safest type of institution you could come up with at the Speedy Bank. At the same time, moving towards the retail, they can already work around it. I'd ask you to maybe have Commissioner Bishop talk about that a little bit and do what's in this bill already through workarounds, and we'd rather be regulating them as a direct application, doing it and then regulating to the retail customer, recognizing then that the Division of Banking will be scrutinizing it from a retail customer standpoint as well. And that is one of the prime use cases. You can imagine a circumstance, for example, where you have somebody that wants to operate a cryptocurrency exchange with direct banking capacity so that you can get into digital assets from a financial institution that you can provide your fiat currency directly to. That's something that a Speedy Bank would allow for, but it has to be fully up and running and have the retail capacity. So it's that type of transition we're really looking at to fully enable and fully realize the Speedy Bank.
Thank you. And sorry, one more question. I apologize, but this is a good education for me. So would you say probably in many cases, that's the biggest driver? Because I won't say I'm a seasoned veteran at that, but investing in crypto is a perfect example of where it can be tricky in a current banking environment. Are these typically used for that case, or is this just one use for them? Thank you.
Mr. Chairman, we have, I would say, one of our 4 Speedy Banks is very particularly interested in exactly that business model. The other 3 of the 4 Speedy Banks are not, and I don't know. I'm trying to think. One of them might have specific retail interests, but it's not all of them that are going to need the retail capacity in the same way. At least 2 of them, I would think, are almost entirely the business-to-business side and wouldn't need these changes of the ones that we have right now. And then we have a 5th one that's, I believe, in the application process now that I'm not sure whether they would need the changes or not. But we've got a significant mix of what people want to do with these special purpose depository institutions, which is great. That's as designed, right? We want to do a lot of different things with them.
Thank you, Senator. Other questions? Representative Lucas.
Thank you, Mr. Chairman. Senator, I would expect, just to clarify, please, that the typical consumer protection laws, the federal consumer protection laws, all apply to SPDIs.
Mr. Chairman, Representative, to the extent that they apply to any banking institution, yes. And I believe, again, this is a good question for the commissioner. I believe his regulatory scrutiny as through the dual banking system is really the key element to the consumer protection. And he's adhering to a lot of federal requirements that we enact often through state legislation, but he has some that he's just adhering at the federal level, is my understanding.
Any other questions for the senator? Senator, thank you so much for taking some time and educating. I
Absolutely.
appreciate it. I'm sure there will be more.
Thank you, Mr. Chairman. Thank you, committee.
Thank you. And can we have the commission, because I think maybe that would be more education for those of us who are fairly new to corporations and may not have seen this. So this is great. Thank you so much.
Thank you, Mr. Chairman. Jeremiah Bishop, State Banking Commissioner, Head of the Division of Banking. Yeah, I'll go through some of the questions that were asked as well as some comments we have, hopefully to clarify some things. And then I'll also speak to the proposed amendment to the bill. Like Senator Gother said, I think the first part, just converting to a state trust company, the biggest part of that is winding down the business of banking. Under Wyoming law, that's collecting deposits. If you collect deposits, you're a bank. If you convert to a trust company, that's the biggest change in the business plan, is you must return all depositor money to your customers. So what we would do is, if this bill passes, is create rules on that process. What do we need as far as that application goes? It's likely going to be around just that. What is your plan for returning customer deposits to the customers so that you're effectively shutting down the banking portion of your business, and then what is left over is the custody side, which is off-balance sheet custody, which would likely remain under the state chartered trust company. So it's things like notifying your customers that this conversion is happening, coming up, submitting a plan for actually returning that money. And then there's going to be other items such as changing, your policies and procedures, and then also changing any filing you have with other states. We're very particular as regulators, not just in Wyoming, everywhere else, about using the term bank in your Secretary of State filing. So things like that, as far as that conversion to a trust company. The second item, just kind of
Can I ask questions as we go? I think it would be almost better if that's acceptable. Any questions for Mr. Bishop? I have one. So can you, to simplify, can you give me a scenario that one of these banks would do that? What would drive them to want to go down that route, that path?
Yes, thank you, Mr. Chairman. Both a trust company and an SPDI are heavily regulated. Our office regulates both SPDIs and trust companies as well as traditional banks. They are different business operations, however. Both of them are heavily regulated, but generally, I'd say SPDIs and banks generally carry higher risk than a trust company. So because of that, there's higher capital requirements is one option. So for an SPDI, to obtain a charter, they must pledge $15 million to our office to be used in the case of receivership. A trust company, we have a similar concept, only that threshold is $1 million pledge, simply because it's a different business model. Also, a traditional bank will have or an SPDI, much higher capital requirements than a trust company because they are having on-balance sheet risk based on their business. A trust company, almost everything is just handling other people's assets or money, or in this case, digital assets. Off balance sheet, it belongs to that customer. You're not taking that risk on your balance sheet. So the risk profile is significantly less, so it comes with it less capital requirements. That's one example of why someone might want to change. Another one is maybe just the banking aspect isn't as profitable as maybe they would like it, as it should be. So it's very expensive to run a bank as well. So running that deposit-taking operations at the bank is very expensive. Maybe it's not, maybe they're losing money, or it's just not generating enough profit. It's better just to cut that off and become a trust company. A couple of examples anyway. There might be multiple other reasons, but.
So just to oversimplify what you just said, which was probably too complex for my my mind. But in short, basically, they started one of these, they found their business model migrated, changed, and they found, hey, the real sweet spot for what we do is this, and the trust supports that. That would be a likely case. Is that accurate?
Yes, Mr. Chairman, yes, I'd say that's accurate.
Thank you. So that just wanted to be sure I was clear. Any other questions on this topic? Because I'm sure we'll hit the next ones. Okay, please proceed.
The next item I'll kind of pair with kind of one of the sections at the end is just the nature of depositors. One, I think is pretty clear, just making that minimum deposit amount from 5,000 to 1,000 and then allowing a 5-day grace period. Again, anytime under the current law, if you drop below 5,000, each instance is a violation that we'd have to cite. As long, the bank has to have processes and procedures in place to make sure that doesn't happen, but those are more technical violations. That's outside of the bank's control. That's the depositor that is gonna go under that $5,000, but we'd be citing the violation on the bank. So this just allows some wiggle room to allow the bank some, 5-day window to notify that customer, you need to bring your balance up to $1,000. If not, then we would cite a violation at the bank level. So it just allows some wiggle room so we're not citing multiple technical violations that might be outside of their control. And then as far as the allowing them to bank individuals, so the SPDI law was passed in 2019. And then I think it was in 2020, there was an amendment to the nature of business. In 2019, there were the initial law prohibited natural persons from being customers of these SPDIs. The change in 2020 kind of, it made it allowed, but it wasn't very direct or clear how it was allowed. Basically, it was saying if you're provide what's called incidental activity to individuals that don't meet that criteria, you're allowed to. Well, incidental activity is defined elsewhere in providing deposits to customers as long as it's related to some other activities. So it's a circular exemption. And it's caused a lot of confusion with our current SPDIs and even potential SPDIs of can we bank natural persons or not. Currently, most likely you can currently. There's a few instances where you wouldn't be able to, but it's very unclear and it's confusing for us, it's confusing for the industry. Since most of the time you already can bank natural persons, as long as there's some other incidental activity such as custody tied to it, let's just call it for what it is and say you can bank natural persons, just to avoid that confusion. Currently, if they bank natural persons, a lot of the questions were consumer protection. Yes, they still have to follow consumer protection laws. Elsewhere within this PD Act and our regulations, it says that these SPDIs must comply with all applicable state and federal laws and regulations. That is very broad. So basically, if we determine the consumer protection law applies, they must follow it currently. So with this kind of clarification that they can absolutely bank individuals, that still applies. So I'll pause there.
Yes, please. And questions? So I have one again, so I'm the slow one up here. So you made the point. So this is really truly just clarifying, people can work around it. This cleans that up. Doesn't change a thing when it comes to consumer protections. Is that accurate?
Yes, Mr. Chairman, that's accurate.
Okay, perfect. Thank you.
I'll move on to the changes in capital. I talked about capital requirements. This change, it does not change the minimum capital requirements at all. Under our law, to be chartered, you must have common stock or capital stock of a certain amount, and then 3 years operating expenses and surplus. For accounting practices, that creates some administrative hurdles and extra steps. Just for the accounting purposes, capital stock and surplus is usually a mathematical equation based on the par value of your stock and the amount paid in for that stock. Generally, any operating company, if you have net income, a positive net income, that goes into undivided profits. Our traditional bank charter statute, it lines out this much is in capital stock, 20% in surplus, and then the projected operating expenses goes into basically a pre-funded undivided profits or retained earnings so that they can draw on those if there's net losses. That's just the way accounting works. This just moves that operating expenses from surplus to undivided profits, where really, it belongs. There's some other reasons for this. If a bank decreases surplus, one, they cannot do so without our prior approval. And then there's restrictions on them, such as paying dividends until they refund that surplus. This 3 years expenses is designed to, this is the de novo company. Most of the time you lose money in your first several years of operations. And that just provides a cushion so that you have enough capital upfront paid in to absorb those losses. And then eventually you start generating income. This just allows for that to happen smoothly without us having to provide approval and put restrictions on an ongoing basis. And that was just some technical talk there, but it does not change the overall capital requirement. It just depends it changes which capital account it goes into. I'll stop there and see if there's any questions on that one.
Yes, just one moment. I'm taking some notes just to make sure I understand, but thank you. Other questions on this topic? Okay,
Okay, thank
please
you,
go ahead, sir.
Mr. Chairman. Next, I'd like to go over the proposed amendment to the bill, which allows an SBDI to convert to a traditional bank. This is a little different than converting to a trust company. I think there's some important policy questions that I think should be discussed and answered. I'll go through several of them. The first item is what capital is necessary to convert to a traditional bank. So there, realistically, you have an operating SPDI. They're currently doing business. They may not be in that de novo period. They might still be in that de novo period, but they're going to have traditional, operating capital currently that complies with our requirements. The way this amendment, I believe, is currently worded, they would have to basically comply with the same capital requirements that a de novo traditional bank would need, meaning 1 year operating expenses would have to be paid into that undivided profits account. That's a policy question. Maybe that's appropriate, maybe it isn't. That's, I think, something that you all get to decide if that is appropriate or not. It's going to be a case-by-case basis. These companies carry different levels of capital based on their operations at that time as they're operating. So the way it's currently is, okay, it may need a capital injection. They might already have it. I'd be curious to see if there's someone from the industry that would like to opine on this topic as well. But I think that's one question that I think you all need to answer is what's the minimum capital requirement upon conversion? A second question I had is just what is the definition of community? So if you read through our traditional bank charter process, which this mirrors, it requires a converting SPDI to comply with the same factors that a de novo application would have to comply with. Most of those factors are based around the convenience and need of the community that they will be based in. Now, this is geared more for community banking, where that is generally just a geographic boundary. If you open a bank in Cheyenne, your community is Cheyenne, or whatever town you're doing business in. It might be a larger institution, and it's Southeast Wyoming. SPDIs generally do business across the whole country. They're generally not as focused on the geographic community as community banks are. So when the banking board or myself are evaluating this factor of the need of the community, what does that mean? Currently, I think it would be a case-by-case basis. I'd interpret that I'd have the SBDI tell me what their community is, and then I would make that decision based on that. But that might be a different standard than a true community bank has. So I think that warrants some discussion on your part of what's the intent of that? What is it? Maybe there's some different factors besides the need of the community that should be applied to these SPDIs, maybe not. The third point is just the involvement of.
I apologize because this is complex. So if anybody has any questions, please feel free. But I do want to ask on a couple of the statements you made, just to make sure I understand. So the conversion to a bank. So this whole concept of they have deposits, and their rules for deposits in these SPDIs is drastically different. Now, conversion to a regular bank, now that the whole deposits retained or whatever is the right terms here, that's a whole different animal. Can you maybe describe that so we understand a little bit?
Yes, thank you, Mr. Chairman, absolutely. So having deposits, that's what banking is. If you're an SPDI, you have deposits that are 100% backed by liquid assets. You don't have FDIC insurance. Instead, you're going to have, if you have $1 million in deposits, you likely have $1 million in cash or treasuries on your balance sheet, basically pegged 1-for-1 to those deposits. So it's the most liquid bank in the country. If you're converting to a traditional bank, that requirement goes away. Now, your traditional bank, you can have deposits however much you want to, but this will go into the third one. You presumably have FDIC insurance. So that restriction of the 1-for-1 backing goes away. The other main change is the prohibition on lending. That's actually my fourth point, but it might be a good time to just talk about it, is now you're allowed to lend. That's been, I'd say, one of the bigger just overall policy statements of an SPDI is that historically, at least when this was first being discussed in, I think, 17, 18, 19, generally you didn't want to mix lending with cryptocurrency. Now, cryptocurrency is held off balance sheet. It does not belong to the bank. It's not on their balance sheet. It's held for the benefit of their customers. Maybe that it's time to lift that requirement, that now you can mix that with lending. Again, that's a policy discussion that you all get to figure out. But those are, I think, the major changes from converting to an SPDI to a traditional bank is the 1-for-1 backing, and then you are now allowed to lend. Now, there's other things you'll have to do as well, such as there may be some other federal laws you will have to comply with, such as bank holding company requirements. There's other ones, CRA requirements, things like that, that you now have to comply with that don't apply to an SPDI simply because they don't lend. Hopefully that answered.
It answered most of it, but what I hear sounds like a relatively complex process, because let's just say I'm a depositor in a SPDI and you're going to become a bank. Maybe I don't want that. So I assume there's very significant rule promulgation required by your organization to be able to do a transition like that. And having, I assume you've probably been through this amendment in some detail. Does it give you all of what you would need to actually do that in terms of appropriate authority, and then give you the ability to make sure a transition like that is sufficient?
Yeah. Thank you, Mr. Chairman. As far as kind of the first part of your question, customer notice, that would definitely be a part of our rules, is you must notify the customer that we are planning to convert from an SPDI charter to a traditional bank charter. Now, I will say they're both banks. An SPDI is a bank under Wyoming law, just because it takes deposits. But that would be one of the items that we would put in rules, that you must notify your customers. We are converting to a traditional bank, and this is what that means in layman terms.
Okay.
And then as far as the second part, does the amendment kind of give us what we need to basically process this application? It leaves a lot to the rulemaking, I think. What application is needed to convert? That is something that would fall on the Division of Banking to promulgate rules of what do we need as far as that plan of conversion goes, and making sure that we have a full application before we even start the statutory process of approving it. Currently, that most likely goes to the banking board. They could elect it to come to us, both for the traditional bank and also the existing language of converting to a trust company. But I think it gives us enough latitude to basically create rules of what we need on a case-by-case basis for that application to be deemed complete before it's even filed. An example of what might be needed, this was kind of the third point, was relation to federal agencies. Currently, SPDIs typically don't have FDIC insurance. They're not prohibited from it. It's just not required. And also with that 100% backing, you don't really need it. In this case, the way the amendment, I believe, is currently worded, assuming that the conversion is approved, you have that certificate of authority to kind of commence traditional banking business. That comes from the Division of Banking. Before we can do that, I believe that's in the amendment, is you must show proof of the appropriate federal insurance. So we would have to work with the FDIC probably before the official application is even filed to make sure that they're okay with this. Because what we wouldn't want is for an SPDI to make an application to us, we get through the entire process, they go in front of the banking board and it's approved, just to get to that portion and the FDIC says no. They need to be involved at some point early on in those discussions to make sure that they're okay with this business. Currently, as I think Senator Rothfuss said, over the last several years, the FDIC and other federal agencies have had zero interest in allowing digital assets in traditional banking. With the new federal administration, there is a definite shift, but we don't know what that's going to look like yet. It's still early on. There's been a lot of changes at the level of federal banking agencies. We have no idea what they're even going to look like next week, much less in 6 months. So we'd have to work with them during this process before, just to save people time and money. I would probably urge the applicant to reach out to the FDIC and have preliminary meetings with them before we even move forward, just for the sake of not wasting time and money.
Thank you. And Representative Lucas, please.
Thank you, Mr. Chairman. Commissioner, so it's fair to say that FDIC has not ever insured an SPDI conversion to a state bank yet. Is that true?
Mr. Chairman, Representative, yes, it's true. We have not communicated with the FDIC at all on whether or not, what their thoughts are on this. Current existing SPDIs operating, I believe one of them did reach out to the FDIC just to explore the possibility of insurance. I don't think they made it very far. One, it was going to be kind of expensive with that backing, it wasn't needed. So I think they kind of stopped having those conversations. So I honestly have no idea what the FDIC currently is going to be with this, or what it will look like in the future based on federal rulemaking or even statute changes maybe requiring this. We don't know what that looks like yet.
Yes.
Thank you,
Representative
Mr.
Lucas, please.
Chairman. So we're kind of going where no one has gone before. Cue the Star Trek music. So is it, I've been out of this a little while, but state banks in Wyoming are required to have federal deposit insurance. Is that not so?
Yeah, Mr. Chairman,
Sorry.
Representative Lucas.
Commissioner, please.
It's not expressly stated that they have to have FDIC insurance. However, that same language of getting that certificate of authority to operate, they must provide proof of insurance, is implied.
So then,
They needed to open business, but maybe
Representative
not
Lucas,
obtain a
please.
charter.
so then it could be understood then that private insurance would be sufficient.
Yes.
Chairman, please.
Yep, Mr. Chairman, Representative Lucas. If an SPDI converted to a traditional bank and there was an option for private insurance, again, that kind of goes up to a policy question on you all, is do you want FDIC insurance or do you want private insurance, a combination, or maybe nothing at all? That's why this is a policy question for you guys to decide what is the appropriate level of insurance for these conversions.
Thank you.
Other questions on these topics so far? Are there more layers of this we
no.
need to discuss here? Because
Thank you,
it
Mr.
sounds like there
Chairman.
might be.
No, I wanted to keep kind of that last bit just on the amendment because, like I said, we did, as Senator Rother said, we did work the original bill with the blockchain committee during the interim. I think that's been vetted over a year almost on that language. This amendment is a little bit different. Policy questions, I think, whether it's not it's decided today on the floor or maybe the interim, that's up to you to decide. We're happy to help as much as we can, whether it's today on the floor or later. because it's a complicated process.
And question for you. So if, let's just say we were to accept this amendment, it is safe to say that we're accepting, and I'm not saying anything bad or good about it, but it is safe to say this is a process that is far from tested. Until we were to take the first instant, it would just open the door for a first attempt, if you will. But still, within your framework, you would have to go through this, all of this process anyway. So it's just opening the door for you to actually pursue this if one of the SPDIs chose it.
Yes, Mr. Chairman, I think that's a fair statement. The whole SBDI concept in general is, entering into new territory. We've been doing this since 2019. So we're used to kind of coming up with new ways to do new things. So if this amendment were to be implemented, yeah, we'd have to figure it out. We're going to have to figure it out at some point either way, whether it's now or maybe if it's next session. And it's going to need ironed out. If there may, I don't know what interest there is in this. From the existing SPIs, we have 4 chartered, 2 operating. So really the only 2 that are operating could convert. We'd have to work with them on a case-by-case basis, really to figure out what we need. And so we would make the rules to allow for that flexibility. I like creating general rules that don't back us into a corner, because each of these business models are very different, and you need to tailor this conversion application on the specific business anyways. So I think this amendment, it does allow us to, I think, start that process. We would have to make emergency rules along with everything else to kind of outline that, but
Okay, thank you.
that's our process.
Thank you. Anything else from your testimony? Other questions? I think, and I hate to do this to everybody in this room, and I will apologize up front, but I actually think maybe we're not at that point. Are there others who want to speak on this bill, for example? Did you travel here today for this? Are you here? So if we move this to Wednesday, will you be able to support? Anyone else in the room who wants to speak on this bill? As long as that doesn't inconvenience you, and I do apologize, Senator, but this is, I think we probably need to continue to hear discussion on this bill, just to make sure that the people up here in the front can make the best decision and support the process, if that's acceptable with everyone. So I am sorry to move this to Wednesday. So Senator, in my case, I always tell people that I failed again at time management, so sorry. But thank you all for coming. I really do appreciate you all being here, and we'll resume on this bill first thing on Wednesday, okay, Mr. Chairman? Perfect. Thank you so much. Everyone have a great day, and if there's no other business for the committee, we'll adjourn.